Good afternoon and welcome. This is the Women Lawyers Association of Michigan. As part of the programming committee, we are hosting a webinar about the ethics of outsourcing legal work. I'm going to hand it over to Mandy, who's going to introduce all of our speakers. So go ahead, Mandy. Thank you so much for being here.
Thank you, Kristen. Thank you, everyone. Our speakers today, the first is Patrice Asamakis. She is the Director of Legal Services at NonLegal. She specializes in helping firms and corporate legal departments gain efficiencies by outsourcing to virtual associates. She's crafted innovative solutions in legal research, legal operations, contract management, compliance, litigation services, and legal analytics. And most recently, she was named Innovator of the Year by the 2022 Legal Week Leaders in Tech Law Awards. Previously, Patrice worked in a large firm, and she has also been a solo practitioner on both litigation and transactional matters. She received her JD from our own MSU and her undergraduate from the University of Michigan. So thank you for being here today, Patrice. And next we have Jeremy Abner, and he is with Structured Consulting. He's the founder there, and he's president of Structured Consulting and a tax lawyer by background. He chairs the ethics committee of the Society of Settlement Planners and has served in the U.S. Treasury's Office of Tax Policy. He regularly consults for businesses in the legal industry to better serve counsel and their clients, and partners with institutions to create new financial and legal arrangements. So he received his law degree in tax Masters of Law from New York University. So thank you for being here today, Jeremy. And also Mary Ellen Marat. She is with Vista Consulting team, and she is the operations consultant to personal injury firms across the country. Previously, she's worked with thousands of personal injury firms on case management software. At Vista Consulting, she advises the firm on all manner of business operations and efficiencies, targeting increased net profits and organized team management. She received her master's degree in human resources development from Townsend University. So thank you for being here today to our speakers, and I will hand it over to you, Jeremy.
All right, thank you everybody for joining. Sorry, I just caught a cold, so my voice is a little off. What we're going to focus on today is the ability for law firms to outsource their legal work when it's been a significantly growing practice over the last 20 years. We'll talk about that growth, why it's happened, kind of what is driving it, who are the firms that are really doing this. And then after kind of talking through the practicalities and why this is being done, we're going to really focus on the ethical issues. All of the ethics issues are quite straightforward. It's just there are a number of them. Most of them can be taken care of quite easily in your engagement letters. You just need to know about them in order to address them well. We'll also turn over to Mary Ellen, who does a lot of different advising, especially to personal injury firms, on different kinds of efficiencies, everything from accounting to human resources. When you're thinking about outsourcing legal work, it's really, you do it because it's efficient. You know, it is improving the quality of the work that you're able to produce, the amount that you're able to produce. It puts you in a bit more of a management role where you're reviewing rather than creating the work that you then also review. So a lot of the things that Mary Ellen's going to talk about are other kinds of efficiencies that fall into that same category. So I'm going to jump into the slides here. So the two main sources that we're going to draw from today, and Mandy, I'm not sure if we're able to send this out to everybody, but you can always Google it. We also co-authored an article in Law 360 a couple of months ago that walks through a lot of these items as well. The two sources we're going to draw from, one is a really great Thomson Reuters study that was done in 2021 that went through all of the different kind of providers that are doing this, they've been called alternative legal service providers or law companies. You've got your law firm, the law firm hires the law company. And so that 2021 study gives us a lot of really good data on the growth of the industry, which firms are using it, how often, and so forth. We're not going to talk much about it today, but Patrice's company, NonLegal, also has an affiliate company that specializes in outsourcing legal work for in-house counsel, for general and corporate counsel as well. There are a couple other kinds of issues, and they often get a lot more into the AI, tech, and workflow. And of course, that can be done for law firms as well. We're not going to focus on that as much today. On the ethics side, we're going to be drawing from a couple ABA rulings, and then there are a plethora of state bar rulings. They are all quite consistent. There are minor differences, and we will talk about those, but the general gist of them are, and you can see on the left here, it's about getting consent from your client, protecting confidentiality, watching for conflicts, making sure you're the one reviewing, and then there are certain rules about billing. When can you pass off the costs? All of the states are focused on those 5 items, and there are very few differences between them. Then we'll turn over to Mary Ellen on outsourcing non-legal services, and we'll also talk about how to choose between the different law companies that are out there. There are a lot of them, and there are a few different, good ways to think about choosing between them, and there are certainly a number of good ones. Okay, so to start out with, what is actually outsourced? I'll turn over to Patrice.
Thanks, Jeremy. The easy answer is anything, everything that you do, short of having a lawyer take a deposition for you, appear for a court appearance, meet with the client, but anything that doesn't actually require boots on the ground can be outsourced. Especially any kind of legal research and writing. That's where we got our start in legal research and writing, and that is probably one of the most common things that law firms outsource. Litigation support of all kinds, pleadings, motions, briefs. When it comes to transactional support, you can also outsource drafting, contracts, wills, trusts, due diligence on deals as well. Any kind of high volume work like bulk discovery is also ripe for outsourcing. Summarization of trial transcripts, depositions, medical records. Technology is an area where many lawyers are looking for consultation. So oftentimes law companies are a bit more tuned in to tech tools, so they can be an excellent resource, both in terms of a consultant, if you're not exactly sure what kind of technology might benefit you, and also for using the technology on your behalf. So really, the answer, what is outsourced? Almost anything can be outsourced.
Yeah, and I think you're where you started with kind of almost like the one thing is it's going to court or advising the client. Other than that, and it's not that different in a way from working with the paralegals in your office, where you're going to have them prep anything for you, serve it up to you to review, and deliver to the client. One point I think is very relevant to note on the technology side, and Patrice said, I very much encourage this. I started working with her company, NonLegal, about a year ago, and then we started working together about 6 months after that, after I'd been using their services for quite a while. One of the things that they'll do, outsourcing is all about efficiency, right? And we'll talk about pricing, what to expect, how to use it, so it is efficient. But since the purpose of using the outsourced company is efficiency, you should expect, if you're working with an outsourced company, they should be very ready and able to consult you on becoming more efficient. And they should be, and certainly Nora does, and a number of the others do, staying up to date with, I think we all know technology is changing very, very quickly, whether it's case management software or doc review software. There's so many different programs that are regularly being released. And law companies like NonLegal are partnering with those companies, staying up to date. So they'll also have good advice for you on ways to become more efficient. But most of all, if you're going to be outsourcing to a team of lawyers outside of your firm, you want to know that they're acting and using efficient programs so that they're not spending more time than necessary, and of course, billing you for it. Okay, so that's what is outsourced. So let's talk about who's actually doing the outsourcing. Back in the early 2000s, this number was very, very low. And then around 2000, 2008 is when the ABA started issuing rulings. I think one of the major reasons why outsourcing took a while. I mean, we all know, like back in the 70s and 80s, outsourcing was so huge, it was this big topic. Everybody was talking about it in all kinds of industries, but not legal, right? Everybody was, thought, hey, maybe we could do it. But on the other hand, are we violating any kind of rules? There's just too much ambiguity, no matter how safe you are. And what the ABA said back in 2008, and a little bit before then, was, oh, no, of course you can. You just have to get consent from your client. You have to protect confidentiality and the other things that we're going to talk about. Once that happened, once it was clear that, no, you just follow the rules, all of a sudden things started moving very, very quickly, both onshore, going to co-counsel, and also offshore, like most outsourcing is done. The law companies, including NonLegal, will go to licensed attorneys in India, in South Africa, in English-speaking countries that have practicing attorneys, train them up in US law, US practice, so that they're able to do this, but at a lower cost of living in the country. We're able to get much, much better pricing and much better support. So groups like NonLegal will have attorneys in the United States doing the work, and also, attorneys in the United States who are delegating and managing to attorneys in other countries to get that significantly better pricing. So we'll get in more to that. But by 2016, studies started being done. Thomson Reuters was one of them. There was already about half of law firms were using legal outsourcing, and even more in-house counsel. The numbers shot up pretty quickly after that. By 2020, which is the most recent year we have stats on, 80% of law firms are using legal outsourcing, around 70% of in-house counsel, largely because those larger companies are also doing more in-house as well. Why are these companies outsourcing? So when we all know, probably the biggest driver is going to be efficiency and cost, and we're going to talk about that. However, if you ask, in these studies, they ask, and the number one reason provided both by law firms and by in-house counsel is access to specialized expertise. A lot of smaller firms don't have, they're slowly expanding the types of work they do. And even within their area, there are, we all know, there's always specializations. There's always some new issue in the case that can kind of just, spider web out into all kinds of different questions. And the ability to go to a law company is a lot like being part of a much, much larger law firm. Most law companies are very large. They have a lot of attorneys that are being used who have worked on a variety of cases. And with that kind of breadth of practice, you're able to say to the law company, okay, I'm about to take on this case. It's in an area or an issue I haven't looked at before. Can you write the research memo to give me a background? Or can you even just write the motion to the court so that I'll review it, and in reviewing it, I will read the cases, I will learn the issue as I am also getting ready to advise my client. So that, I think that's one of the main reasons that's such a top answer as why people are using it. Okay, then after that, it really gets into efficiency. So offering the client the option to control costs. We're going to talk later about billing practices, but of course, if you're able to say to your client, hey, we could charge you, 10,000, or we could charge you 7,000 or 5,000 by doing this, your profit margin should be the same or better. You're just doing less work on that matter, so you're able to handle more matters, and your profit margin is higher. So at the end of the day, you do better, and the client gets a better rate on the work. A couple other big ones that jump out are like meeting peak demands without hiring. This is where, I mean, especially for a mid-size or a small firm, you get that really big case, or you happen to get 3 cases all at the same time that are larger, and you're kind of built for 1 or 2 big cases and a lot of little ones. All of a sudden, you've got that inflow. By going out to the law company, all of a sudden, your bandwidth is very flexible. You can bring 20 additional lawyers to the table if needed. And of course, maybe it's just 3, but either way, it's more than the current team. Okay, so that's kind of, those are the key reasons why. Mandy, by the way, I see some of your reactions. I can tell that you have seen some of these issues come up. Please feel free to and this is true for anyone else. Feel free to jump in with questions, observations. A lot of this is, we're going to talk about technical rules and ethics, but this is about efficiency. This is about being practical. So if you have thoughts on ways to be practical or issues that are coming up in your practice, I think one of the most helpful things is to talk through, how does it show up? How could it be implemented in a particular practice and be helpful? Okay. Okay. Next, and I'm almost done and gonna pass off. But here we said, one of the key reasons, of course, is efficiency and cost. So this is going to be an example of how that might work, and then we'll shift gears. So let's say, and these numbers are totally out of nowhere, but I think they're good example numbers. So let's say you have a project. It's going to take, at your firm, normally it would take you about 10 hours of team time. And you charge about $2,500. Let's say it's a flat fee. This works for hourly billing, but it's even simpler for a flat fee. So let's use that as the example. Okay, so let's say on this project, maybe it's an estate plan or a contract, or submitting, a demand letter, complaint, and the next 2 steps of the litigate, whatever it is. You're planning on your paralegal spending 8 hours to research, prep, and then you, the lawyer, are planning to spend 2 hours to review and finalize. This could easily be the associate and then the partner, or the paralegal, then the associate, then the partner. The point is, there are going to be 10 hours of team time spent, and the cost to the law firm of the paralegal's time, that first person's time, is much less than the second person. So the paralegal, maybe they're billing at $75 an hour, whereas, I'm sorry, not billing, maybe it costs the firm $75 an hour to employ that paralegal. So his or her wages plus his or her benefits and healthcare and so forth. So that's $75 an hour. Then the lawyer will cost the firm $300 an hour, and that's for their, again, wages and benefits. Now, of course, the lawyer might be charging $500 an hour, and that's where the profit margin is. But that's the 300 hours what it costs the firm. Okay, with those 10 hours, you're charging $2,500. That's $1,300 of profit. So of course, you know what's coming next. The next step is, how are we going to increase the amount of profit by using an outsourcing a law company? So for example, Patrice's company, NonLegal, if you're on a subscription plan, they charge $20 an hour for licensed attorneys to be doing this work. So let's say that you actually give to Patrice's team 10 hours of time. At $20 an hour, it's only $200. So you're already at 10 hours of work before you've even gotten to a third of the cost of your paralegal. That's where the efficiency is coming in. So you've got these outsourced associates, they're already doing the work. Now, at that point, may just be ready for your eyes as the attorney. But let's say that you are a particularly picky person. You've got your own style, you've got your own way of doing things, and you know the judges, and so does your paralegal, knows the judges really well, knows exactly what they want, also knows the client. There are certain things to be done in very special ways, and we all know like that's very common. It's not going to be about the law, because that's what the outsourced associates are going to be doing. They're going to know the local law, they're going to write it up. But you have your own way of doing things, and you need consistency if you're going to be efficient. Because if you get memos in different styles and things like that, and of course you want to give examples to the outsourced associates so they can mimic that. But at the end of the day, you're doing things your way. So next thing that's going to happen, you're still going to allocate 4 hours of time to the paralegal at $75 an hour. You probably don't need that much, but let's just say we're being generous. And so your paralegal is still going to spend 4 hours. Then on top of that, you're still going to spend an hour reviewing. This memo must be really perfect at this point. You have thrown a lot of hours at it. Okay, and yet the cost to your firm is reduced by about 400. So now your profit has increased by about 30%. That's in general, and this isn't specific to the legal industry, right? This is just outsourcing in general. You're able to get a fair amount of the work done that you would normally do at a lower cost. And for example, one of those types of work might be when you have a legal issue or a memo to write, a motion to draft, and you haven't looked at this particular issue before. For me, at least, and I think this is generally true, the most time-consuming part of this project is that first period where you're kind of cracking away at the keyboard, trying to come up with the right search terms, finding the right cases. Okay, finally, now I get it. This is the term I should have been searching for this whole time. Now I'm searching for it. Okay, I'm starting to get the right cases. That's the stuff you don't need to do that. A partner or an attorney doesn't need to do that. That's the reason that we allocate work to paralegals. And this is the same is true with a paralegal, even managing and allocating that work to the outsourced associates, because once they do that, then when you get involved or when your paralegal gets involved, you already have, you're kind of starting way ahead of the starting line. You already have those relevant cases, those relevant citations. And now when you're reading cases that are directly relevant, and maybe you're going to think of new ideas and go in different directions, but you get to do that with the benefit of starting at further along in the process. So that's kind of the short version of outsourcing. Okay, so that's the reason why it has become so popular. Now we're going to dive into the actual ethical rules and how you can protect yourself. Again, these are all very, very doable, but very much worth knowing so that you're doing it the right way. So first we're going to, and each of these here, we'll talk about them. They're different memos from and rulings from different bar associations. But we'll start with consent. Patrice, do you want to take it from here?
Sure, thanks, Jeremy. We're going to get into the model rules now, as Jeremy said. All states have adopted the ABA model rules in most respects. Michigan does not have any specific issued opinions. So I imagine most people watching this are Michigan lawyers, but just in case you are admitted elsewhere, there are a handful of state and local bar associations with issued opinions on the topic of consent. So if any of you are in Ohio, New York, DC, North Carolina, Florida, and then there are some local opinions in San Diego and LA, take note of that. But as I said, in Michigan, we don't have anything issued. We all know Rule 1.6a, we all learned that in law school, that we cannot disclose information without consent. Most clients are going to understand the financial benefit of outsourcing, as we saw with Jeremy's, a few slides ago, Jeremy's explanation of the cost. So approaching a client on this, most clients are going to be receptive and they're going to want to understand how you can help save money. So the easy answer here is include the authorization in your engagement letter. Make sure it's broad enough in scope to cover a law company's services. An easy fix for that is simply to indicate that you may assign or allocate work among, and then typically it would say paralegals, legal assistants. If you just throw in the term paraprofessionals to gain efficiency, you will be covered. This, as I said, is usually a positive conversation because the clients want to hear that they're going to get value at a lower price point. Rule 1.4A2 says a lawyer shall reasonably consult with the client about the means by which the client's objectives are to be accomplished. Again, clients are receptive to this. It's usually a positive conversation. And if you just set it up right from the get-go in your engagement letter, you'll be covered and you don't have to worry about it after that.
Okay, confidentiality.
Sure. Okay, confidentiality. So what do you do to protect your client's confidential information when outsourcing? Of course, we all understand this is a super important topic. We all know that Rule 1.6 says a lawyer must act competently to safeguard information against inadvertent or unauthorized disclosure. Most law companies are going to have something in writing, either by virtue of a separate written confidentiality agreement, or in the case of NonLegal, this confidentiality is included in our terms and conditions. So whether it's a formal agreement or whether it's on the website, just be certain that somewhere the law company is obligated to maintain that confidentiality. We do this at NonLegal all the time. A couple of recent examples where we've gone above and beyond just the obligation in the confidentiality terms that say we have to keep the confidence. We had a high-profile case in LA in the entertainment industry where a film's investors needed a little bit of extra protection. So our client sought and obtained a protective order. And although we already had the terms and conditions of our website, and in this case, it was a subscription client, so there was a separate written agreement with confidentiality terms, but we also had every NORA lawyer who touched that file execute a confidentiality agreement in his or her own name. So that was just a little bit of an extra level that the client needed in that case. We also had a client right before COVID who was a telecommunications company that needed document and contract tagging. All of the documents contained personally identifying information. So there was an extra level of confidentiality needed in that case too. We actually built a facility and we are a remote company. We've been a remote company since 2005, but when a client's need arises, we try to address it best we can. So in this case, we built a facility where all of the data remained on site and our lawyers had to check in and out on a keypad, had to leave their personal belongings, their computers, their phones in the external area and only work on client provided laptops in a secured work area. So those are two probably a little bit more extreme examples. Those things don't happen every day, but the takeaway for you is that if you ever have any specific confidentiality concerns, you should be able to talk to your law company about that, and you should expect that those concerns will be accommodated in whatever way that makes you feel comfortable.
And I think just one last point is the ABA did their 2020 commission. They actually did a study where they were looking at different law companies. And they said what they found is most of the time that companies are watching out for these issues. So like what Patrice is saying is, if you're working with a law company, just make sure to ask about that. We all know, the first vetting question usually gets you a lot of information. Just, hey, what are you doing to guard my information? Tell me about it. Just that open-ended question. Okay, conflicts.
Sure. So Model Rule 1.7 states that a conflict of interest exists if your representation of a client will be directly adverse to another client, or if that representation will be materially limited by another client or former client. Again, no rule in Michigan issued on this particular topic, but the ABA advises that a law company must not work for adversaries of clients on the same or substantially related matters. So it's important to ask your law company what their procedure is and verify that they're not working for adversaries. Conflicts do crop up, surprisingly. I was surprised to learn, thinking it's such a big world, and we have clients all over the globe and associates working from all different places. You would think that conflicts wouldn't arise that often, but they do. Our conflict check procedure is similar to what a law firm does, and we have from time to time had to say no. So it's important to make sure that you inquire about that. This Florida opinion is interesting because it says here that the lawyer could be held responsible for any conflict of interest that may be created by the hiring of the company, which could arise from relationships that the company develops with others during the attorney's relationship with the client. So could be held responsible is an important concept. And for you, whenever you're looking at a law company, the bottom line here is to just ask. It may be a written policy, it may not be, it may be something that you have to, information you have to solicit from. But at the end of the day, you need to understand that conflicts do arise the same way that they arise for you. And a law company should not work on something if there is a conflict.
And I think one thing worth emphasizing, the whole could language, we all know that there in business, there are plenty of companies who, if the rule is, well, maybe you should not do this, then there are plenty of businesses who are going to do it. Because the rule isn't, there's also the companies who are going to do it even still. But there are plenty of businesses who are going to do something when there's a gray area, and then feel like they can go out and plausibly say, we follow the rules. You do not want to be working with that company. And so again, here, just asking that question, what is your process, for checking conflicts, and when there is one, what do you do? Patrice's, what NonLegal does is, much more, they are acting like a law firm. That's really what you want to see. If you back away from that and you start playing in kind of the ambiguous area, you might be liable, you might not be liable, but you're now in this world where a client has a valid reason to object to something you've done. And there are plenty of companies who you can work with who wouldn't expose you to that liability. Okay, review.
Sure, okay. So diligent review really comprises two separate components. One is competence, and one is to avoid the unauthorized practice of law. So first, we'll take competence. Rule 1.1 states that a lawyer shall provide competent representation to a client. And what this means in terms of allocating to a law company is that you are ultimately responsible for the work product. Interestingly, the ABA says that your decision to use a law company may be based on its reputation. So that sort of goes hand in hand with the competence question. Do a little bit of questioning at the outset. We regularly put prospective clients in touch with our existing clients. Of course, the internet's always helpful as well, but hearing from a current client is probably one of the best sources you can get. The extent of diligent review depends on the circumstances. So if you delegate a project and you give your service provider the arguments, so say you're going to delegate a dispositive motion and you know the parameters of that argument, and you give that law company your arguments and say, this is what I want it to look like, go do the research, make the arguments based on this. If they return something to you, you still need to review it. You can't just sign it and file it, even if it's marketed as file ready. And a lot of law companies will use that term, that their pleadings and briefs are file ready. You still have to read it. You have to own it. You have to make it your own. What this means is that you either need to investigate or use your own professional judgment. But another important point there is that we touched on the issue of technology earlier. Competence probably includes some relevance in technology as well. The comment to Rule 1.1 says that you must keep abreast of changes in law and practice, including the benefits and risks associated with relevant tech. Michigan is one of the jurisdictions that has adopted that rule. So this can mean legal practice tools, data security, litigation, e-discovery. In any event, the competence and the diligence sort of go hand in hand. Competence means find out about your law company, find out what kind of tech they're using. Diligence means that at the end of the day, you have to own it. Probably one of the questions I get most often from prospective clients is, how does unauthorized practice of law work? How do we avoid that? If associates in other states, because we do have a US workforce as well, so we do have lawyers all over the country, as well as offshore in India, and other law companies may have associates in other English-speaking countries, such as the Philippines, South Africa. So the question I get is, how is this not the unauthorized practice of law? You cannot assist another in the unauthorized practice of law, so that as long as you maintain an appropriate degree of supervision, it's okay. As stated, there's no checklist, but if you read it, you understand it, you own it as your own. Doesn't mean you have to edit it. It doesn't mean you have to make changes to it, but you just have to sort of take ownership of that. I always think of this level of review as, what would you do if you were reviewing a first or second year associate in your firm? What level of review would you give that? And that level of review is probably going to be appropriate across the board. So when it comes to review, you have two things to think about: competence. What's the competence of your law company? What's their reputation? What kind of tech are they using? And when it comes to review, you need to read it for yourself and take ownership of it before you sign anything. I will add, before we go any further, that review, it's probably a little bit of a different standard with pleadings and with research, because in the case of pleadings, you're actually putting your signature to it, or opinion letters or anything that you're going to sign. In the case of legal research, there's no issued opinions on that, but it's probably, the review standard there is probably a little bit lower. But in any event, as I said, there are clients who sign work that they've received from outsourced companies without reading it, and that is not advisable. You need to read it and take ownership of it.
Yeah, at the end of the day, outsourcing, it's still coming from your office. So I think the way you're describing it, that makes sense, Patrice. When I think about it, I think about whether if I have a paralegal or, like you said, a first, second year associate. They put it on my desk. Now it's on me. I'm the one sending it off. But hopefully I'm working with a law company that, just like a paralegal that I've worked with for years, I've learned to trust. And so I'm going to consider that as I'm reviewing the work. And hopefully the quality of the work is high enough that as I review it, I'm checking, everything's fine. Maybe I make one or two edits and I'm able to send it off. Okay, last one is billing.
Sure. So the baseline here is that you can't charge an unreasonable fee or an unreasonable amount for expenses. Again, Michigan does not have an issued opinion on this. Anybody in other jurisdictions, please check your local state, county, or city bar associations because there are some variances. So there's a couple different ways to do this. There is the straight cost model. That is pretty self-explanatory. If you pay a law company $450 for a project, you pass that $450 on to your client, done. No ethical violation whatsoever. Then there's cost plus overhead. If you pay your law company $450 for a memo, you can charge that $450 plus your own review time. That would count as what overhead means. And then there is the marked up rate, cost plus surcharge. Generally speaking, most bars will say anything that is reasonable is fine. And there are some opinions that say anything that is outsourced at less than your lowest associate rate is acceptable. In this regard, we at NORA offer both flat fee projects and hourly billing. For any flat fee projects, we record our hours spent in your client portal so that you can use hours rather than just passing on that flat fee. In other words, if you're going to bill that out at an hourly rate and you pay us $450 and you look in the portal and you see that that took us 6 hours, you would be allowed to bill for 6 hours of work there. And then of course, if you have an agreement with your client, you're all set on billing.
And as we were preparing our article for Law 360 on this subject, we also reached out to a couple different members of the ABA Committee on Professionalism and Professional Responsibility. And one of the things in speaking with them, they kind of repeatedly noted was it's kind of become industry standard. What Patrice was saying, that as long as you're billing below the lowest rate of your associate, and the idea being, hey, you know what, you bill for your paralegal's time. The law company's attorneys are licensed attorneys; they're just not licensed in your state. So you probably shouldn't be billing them at rates that you would bill your regular associates. But as long as you're billing lower than that, that seems to kind of become the industry standard. Okay, then in terms of how to choose between them, and then I'm going to be turning over to Mary Ellen. Very high level, what we would recommend, first of all, we've been kind of repeating, like, make sure they're monitoring for malpractice. You can ask a few basic questions. Make sure they're training their lawyers in US law. This should be standard practice for every law company. It's certainly not a guarantee, so you want to make sure that you're not paying for the training. Make sure they're following they're following updated technology. Obviously, if they're not using the updated technology, then they're not the most efficient place to be doing the work. And the whole reason you're doing this is for efficiency. So that would kind of defeat the point. And then the last is guarding for responsiveness, especially because a fair amount of law company work is done offshore. It might be done in a different time zone, which can have really, really good benefits, right? You submit, you've done your work all day. Now there's still things that need to get done. You ask for it in the evening. They're working on it overnight because that's their daytime. And that can be a real benefit. On the other hand, if they're not going to be responsive, that's going to be incredibly inefficient. We all know how to check to see if people are being responsive, but I certainly recommend do that before you start working with them. Last thing is, try them out. One thing Patrice's company, NonLegal, offers any CLE audiences is up to 10 hours free on a first project. Certainly, like using it for a research memo or something like that, it's a great opportunity. There are other companies that will do similar things, but that's a great way. One of the attorneys that I spoke with a couple months ago, I think what she did is she was working on a memo. She asked NonLegal to work on the same memo. And when she got back from NonLegal, they found a number of cases that she hadn't found, and she plugged it into her memo. Another attorney, this was from a couple weeks ago, he actually just used their memo, and he plugged in a couple of arguments that he had been thinking about. So I think a great way to start out is where you're doing the work and you have them doing it as well, so you can get that confidence of quality. And then after that, you'll know the quality's there. You won't need to do a double time. Now you'll just review. To do that, if you like, on the NonLegal site, there's that, the code here is 10 free. And you can, of course, email us or email Patrice to ask about that. Okay, so now we're going to shift gears into other efficiencies outside of outsourcing for legal work. And here, Mary Ellen's going to talk recruiting and hiring, missions value. Well, you know what? I'll turn to her because she's going to say it anyway. Mary Ellen, go ahead.
Thank you so much, Jeremy. And thank you to the Women Lawyers Association of Michigan for having us. We're excited to be here today. Okay, so we've talked a lot about outsourcing the legal work and how efficient and effective that can be for you and your team, but know that there's also plenty of opportunities to outsource non-legal work as well. And that can be just as efficient and effective for your firm. It can allow you to hand off those really time-consuming or internally taxing tasks or projects. And it can free up your team to sort of focus on those projects that are really, honestly, a better use of their time and skills. So at Vista, we see firms outsourcing many, many projects that fall into really what we call the business side of running a law firm. And I'll go over a few of those projects as well as provide some guidance to allow you to really make those projects count and really pay off after that initial investment in the outsourcing. So my basic word of warning is if you're going to outsource non-legal work, you want to put the work in to make sure that investment counts. So let's look at one specific area that Vista Consulting sees firms outsource a lot. And I think this makes a lot of sense right now. I think everyone listening to this webinar and everyone presenting on this webinar can attest to the fact that the labor market is absolutely bananas right now. Talent acquisition is hard, it's expensive, it can be incredibly tough to get right. So oftentimes we see firms stumble with recruiting and hiring talent. So they'll outsource that process. They'll get their candidate in the door, they'll outsource to get the person in the door, but then they'll really fail to set that candidate up for success. So if your firm is thinking about outsourcing recruiting and hiring, think about too those internal processes and procedures that your firm has in place that might help to ensure that your new top talent does reach their potential and does become a longstanding member of your firm. So just a couple of tips to make sure your firm provides to every new team member if you're going to go down the path of outsourcing recruiting and hiring. A successful day one. So you want to make sure that you're creating excitement for this team member before they even walk in the door. You're letting them know what to expect, what to wear on their first day, where they should park on their first day, whether or not they should bring lunch that first day. All of those things that are going to make their first day a little bit more smooth. You might even consider something like a greeting committee or a buddy, somebody that could help that new team member navigate day one and make them feel very welcome into your firm. You might even consider giving them swag that, has your firm brand on it so they can feel like they're immediately a part of something larger with your firm. You want to take a look at your onboarding processes and make sure those are really solid. We like to say at Vista that it's our job as managers to provide every team member with the tools, training, and expectation to do their job well. So let's make sure that our onboarding processes really do set people up for success. I will argue that onboarding process, it's not just the paperwork. I would argue it really does last that whole full year of a new hire's time with your firm, because that's them getting in, getting used to your culture, getting used to their job, getting used to how things get done at your firm. One of the things that can help with that is training manuals. You want to make sure that you've got some very clear and effective policies and procedures, and putting those down in manuals where you've got screenshots of your, if you're using a case management software or other kind of accounting software, make sure you've got screenshots, make it really easy. Any vernacular that you use in your firm, maybe you have codes for things that might not translate to other firms, make sure you've got like a little dictionary so everybody who joins the team knows what those things are. Make sure your team knows where to find those things and make sure you keep them up to date. And then ongoing education. It's important that we provide ongoing education opportunities, not just to our attorneys, but letting every team member really grow and develop in their role will help them hopefully stay true to your firm. And lastly, culture. You want to make sure you're introducing new team members to your firm's culture thoughtfully and helping them really embrace what your culture is. You know, every firm has a culture, whether you cultivate it or not. So you don't want that culture to develop by default. You want to put some intention into it. All right, Jeremy, you can pop on to the next slide. Okay, another area where we see firms outsourcing is in creating a mission, a vision, a set of values, a brand. That's another great project where you can get some outside help. And it's actually one of my favorites to walk through with a firm. You can certainly do this internally, but I think it can be really valuable to have an objective third party walk you through the process, push you on it, help you think it through. It's also another one where you want to make sure that your investment is worthwhile by doing things right on your end. So in this case, I'd like to start by getting feedback from your team. At Vista, we've worked with firms on mission and vision projects, and I really like to start out with like a survey monkey to the whole team. It can be so eye-opening, and you'd sometimes be shocked to hear the insight from your own team when you ask them very pointed questions about your firm's strengths, weaknesses, and get their suggestions on where to focus for things like this. A note on self-awareness. I think it's really important to have self-awareness of who you are as a firm. You know, no one wins when you try to pretend to be something that you're not, and people can really sniff out something that's not authentic. So that's not to say you can't work on your culture and work to improve it or cultivate it. But if your firm is incredibly buttoned up and you're closed off and you skew uber professional, don't put in your mission, vision, and values about this, you know, warm family atmosphere that you have, because that's just not authentic to who you are. And again, you want to make sure you're developing that culture by intention and not by default. So cultivation, this is not putting together a mission, vision, values, and brand for your firm. This isn't an event. This is a process. It requires cultivation. It's not set and forget. So remind your team often why you do what you do, why they do what they do, and how they fit into that. So you can use it in reviews, you can use it during meetings, during decision making, and you can ask yourself, you know, does this decision bring us closer to our firm vision? That can kind of help sometimes in that decision making process. All right, Jeremy, you can go on to the next one. So Jeremy and Patrice mentioned technology earlier. Obviously at Vista, we think the technology that you use at your firm is incredibly important, and data itself is incredibly valuable for law firms. So that's why at Vista, we see firms outsource often projects that are related to reporting and dashboards. Again, these tools can provide you with such a gold mine of insights. It can help you identify bottlenecks at your firm. It can help guide your future decisions. So again, I think there's some, you know, good best practices to make sure you're getting the most out of an outsourced project if you're having somebody help you develop those reports and dashboards. First, you got to collect the data. You know, step one for any reporting project is making sure that the data you want to report on is actually being collected somewhere at your firm. So I cannot tell you how many firms we work with who will go in and they'll give us a beautiful set of wish list reports. I would really like to, you know X, Y, and Z. But when we actually dig into their case management system or look at the processes they're using now, they're not actually tracking that data anywhere. So you can't report on those things that you're not tracking. Meaningful data. So we've all heard it a million times, but it's true. Garbage in is garbage out. So a lot of times when we go in and start doing reports, start helping firms put together dashboards and reports, those kind of first set of reports really uncover all kinds of bad data or missing data. You know, maybe it's the firm is putting data in the wrong field or in the wrong format, or they're just not putting it in at all. So in order to make your reports meaningful, you have to clean up your data that you have in your system now, or you have to say, you know what, I'm going to set a firm line. I'm going to begin doing this properly from this point in time. So I know all of my reports after Jan 1, 2022 are going to be correct, and know that there's going to be some ugly stuff in the reports that you pull from before that time period. And lastly, accountability. You know, I think a key power of reports and dashboards is the ability to use them to hold your team accountable to their goals, to their KPIs. So you want to make sure you're not reporting just to report, but you want to be holding regular meetings with your team to go over their numbers. You want to either have somebody on your team or a trusted partner to whom to outsource that can help you really analyze those reports and look at those data points. And next slide, Jeremy.
And Mariela, I know on the data side that I've seen that really pop up as something that where action can change. A couple examples of maybe one or two that are often jump out as, okay, the firm could be doing something differently and benefit significantly from it.
Sure, absolutely. So one of my favorite sets of reports is actually pulled from closed cases. So we'll look at closed cases reports. And when you start looking at, all right, this case is closed out, it's already been through our system. Let's take a look at how long those cases were in our system, our time on desk. And then let's drill down even further and say, for those closed cases, how long they were in our system. What about the ones that closed with a fee? And what about the ones that closed without a fee, where maybe it was a case that wasn't worth anything, or it was a case where the client fired us, or whatever happened, but we didn't collect a fee on that case. And really digging down into, are we keeping those in our system for way too long, where we're now, wasting money by putting our resources and money into these cases that aren't generating a fee? So sometimes really drilling down into those closed cases can help us see where we might be able to make decisions a little bit sooner to flush those cases out of the system, so we can spend our resources on those cases that really are the most profitable for the firm. Of course, I also love intake reports as well, because they can really help us drill down on where our cases are coming from and allow us to make some marketing decisions on where it might make sense for us to up our spend or maybe downgrade our spend because we're not getting what we thought from a certain referral source or a certain advertising source.
That makes sense.
Okay, lastly, accounting. Many firms, especially we see it a lot with smaller firms, prefer to outsource their accounting, and that's often a very wise move. Just want to make a couple of caveats that I think you should be aware of. Industry knowledge, accounting knowledge, obviously key, yes, but make sure that the company to whom you are outsourcing also really understands the legal industry. As we all know, it is a unique beast. So you want to work with someone who understands and knows those nuances. Fractional CFO, that is a buzzword that I'm sure we may all be starting to hear quite a bit. We just at Vista rolled out fractional CFO services as one of our bubbles of service. What it really means, if you haven't heard this buzzword, is using an outside company outsourcing your accounting task that would typically fall under somebody with the CFO title at the firm. So if you're going to go that route, if you're going to hire a fractional CFO, make sure you're looking at somebody who understands and speaks with you about setting and reviewing budgets, analyzing your accounting reports, and analyzing things like your tax structure. Is there something you could be doing better or more efficiently for your tax structure? And lastly, you might want to look at financing case costs. We often see PI firms using their operating capital to finance their case costs. In a growing firm, that can really strap your operations very quickly. So something you may want to look into. And really with all of this, the point that I want to hammer home is to make sure you're making the most out of those investments that you might have in outsourcing by setting your firm up for success. I think it's become obvious at the end of this webinar now that outsourcing can be incredibly effective and efficient. Just make sure you're taking a look at that underlying infrastructure to ensure that you get the most bang for your buck with whatever project you decide to outsource.
All right, well, thank you. Mandy, we're glad to take questions. I know there's going to be a number of folks watching by recording, but thank you for the invitation. If there's any other, if you have any questions or Kristen has any questions, but otherwise I think that kind of takes us to the end.
Yeah, so a couple of questions that did come up is how much is a consultation typically?
Oh, Patrice, I think you're muted.
Yep, sorry about that. For NonLegal, it is completely free of charge. We regularly consult with prospective clients with no expectation. So I'd love to have a call from anybody.
And another question was, how does one get started in outsourcing? Is that something you can...
I can answer that for NonLegal, and Mary Ellen, if you want to answer that for Vista, please feel free. But for NonLegal, it sort of depends. If you know exactly what you need, for example, a research memo and you have the issues set out, or a response to a motion, you know the parameters of what that response is going to look like, you can use our online submission form. We have plenty of lawyers who just upload their information and it's pretty seamless. But we also find that there are some folks that want to actually talk to a live person. So I am available anytime. Just reach out. My email should be somewhere in this presentation. You can get it from the Women Lawyers Association. And I also have a colleague who works with me, and we both do intake. So we would be happy to speak to you about any project you can get started with.
Yeah, and from the Vista perspective, the way that we typically work with a law firm, I would say that the most common path throughout outsourcing any services to Vista or working with us for ongoing consulting is really to get a firm assessment. And what that is where our operations consultants come into your firm and really take a look at everything from soup to nuts, all of those things that have to do with the business of running a law firm and kind of where you are now, meeting you where you are now, and then making suggestions for what we see as opportunities for additional efficiencies or additional areas that could be done more effectively or done more to best practices. And then we'll provide that roadmap to the firm, and it kind of goes from there.
Thank you so much for that. And we are a bit short on time. We're at 1:04. So like Patrice said, if anyone has any questions for the speakers, you can reach out to Kristen or myself or to the speakers directly. And we'd be happy to get you their contact information or convey those questions. And with that, I'll hand it over to Kristen.
Thanks, Mandy, and thanks, Jeremy and Patrice and Mary Ellen, for being here with us today. It's always been a subject of interest for me to learn more about, because I was on the outsourcing side when I first started practicing, and now I'm in-house. And these issues constantly come up, even just working with outside counsel, like what information needs to be shared and whatnot. So thank you so much for taking the time to give this presentation. And we look forward to hopefully partnering with you again soon. Have a great afternoon, everybody.
Thank you.
Thank you.
Yeah.
Bye-bye.
Bye-bye.
Bye.